what is important to consider at this stage is context. There's an overall context in which the evidence in this case must be viewed. The prosecution would have you at this stage look at the case vis-a-vis events that are discrete and isolated, that we lawyers can quibble about before the court. Well, this document says this, and look at this signature, and look at that spelling. Yes, those things matter, but there's an overall context that is a common thread that runs throughout this case. The prosecution cannot hide from it at this point. And what is that common thread? That common thread is a mode of liability called joint criminal enterprise. That is what holds this case together. This case stands or falls on that mode of liability. It doesn't end there. There's something else that's of importance. You have in this case the charge of terrorism. Terrorism is a specific intent crime. In civil law systems, they refer to it as special intent, dolus specialis. Dolus eventualis will not suffice. Recklessness or advertent recklessness, that will not suffice. So in addition to this notion of a shared intent, it has to be of a special nature, dolus specialis. That means Mr. Taylor must have as his specific intent and as his purpose to cause terror in Sierra Leone. The other members of the JCE must have the same intent. We will come to that because the prosecution's case begins to crumble as you begin to look into this issue. When you look at the issue of the continuity or lack thereof of the alleged JCE, and you ask the question whether the various members of the JCE, in its various manifestations through the years, a long period of time, 1988 through 2002, whether they all shared the same intent, I submit to you that there is no such evidence. The prosecution's brief does not address that issue in any depth whatsoever. They don't address the issue of the specific intent vis-a-vis the other members of the JCE. This is where you apply the law to the facts. And we're no longer speaking about allegations and theories. We're looking at what the evidence shows. Now, we leave Libya, and the next place of interest is Burkina Faso. Following Suwandi Kamara's evidence. Suwandi Kamara says that in Burkina Faso, that there was a meeting in Burkina Faso. He starts out by telling us that the Liberian delegation to Libya and the Sierra Leonean delegation all ended up in Burkina Faso after training in Libya, and that in Burkina Faso they also met the Gambians. And he says in Burkina Faso there was a meeting between Charles Taylor, Fode Sanko, and Dr. Mani, where they each agreed to help each other take over power in their respective countries. That's his evidence. Take over power in their respective countries. I don't recall him saying anything about pillage the resources of their countries. The fact of taking over political power, is that a crime that this court has the authority to consider? That issue arose in Your Honor's AFRC trial judgment. Who else spoke about Ouagadougou? Moses Blah spoke about Ouagadougou. Moses Blah told the court that there were no Sierra Leoneans to be found in Ouagadougou. Following the NPFL's training in Libya and when Taylor went to Burkina Faso. You notice how this is evolving. I have not even mentioned the defense witness. This is prosecution evidence. Moses Blah. There were no Sierra Leoneans in Burkina Faso. If Moses Blah says there were no Sierra Leoneans in Burkina Faso, how did this meeting take place that Suwandi Kamara is referring to? A meeting between Dr. Mane, Fode Sanko, and Charles Taylor. Conflict between their witnesses.